A deposition is a time for the attorney representing the defendant to ask you questions under oath about your case. This testimony may be used if your case goes to trial. The deposition usually takes place in a lawyer or court reporter's conference room. Even though you are not in a courtroom testifying, the seriousness of your case remains the same. Present at your deposition will be your attorney, the opposing attorney, a court reporter who will record every word said during the deposition for the court records. Later, the questions and your answers will be typed into booklet form. If the deposition is going to be videotaped, a camera operator will also be present. Your attorney will be with you during your entire deposition. The other attorney is on a fact-finding mission about your case. During the deposition, he wants to find out what you know, what you will say at trial, and what sort of impression you will make. How you come across can greatly impact the outcome of your case. Your attorney will meet with you before your deposition to review the specific facts involved in your case and the types of questions that you will probably be asked. The purpose of this videotape is to give you general information about a deposition and a few of the do's and don'ts in order to be a good witness. First, let's talk about your personal appearance for the deposition. Your appearance can affect how the opposing side evaluates the case. You should dress much like you would for a special occasion, such as a job interview. Women may wear a skirt and blouse, or dress slacks and a blouse. Men should wear nice slacks and a collared shirt tucked in with a belt. Do not wear jeans, shorts, or a t-shirt. Women should avoid wearing too much makeup. Hair should be brushed and appear well groomed. Your clothes should cover tattoos and body piercings. Jewelry should be minimal and facial jewelry removed. Here are some rules to follow while giving your deposition. Arrive early. It is good form to arrive about 15 minutes early for your deposition. If you have to wait, don't talk about any part of your case, including your injuries, with anyone other than your attorney. Always tell the truth. The court reporter will swear you in and ask that you swear or affirm to tell the truth. You are under oath, so everything you say must be completely true. If you do not know the answer or do not remember, say so. Do not guess. If you guess wrong, you have lost credibility and may have irreparably harmed your case. Do not be embarrassed if you do not understand a question or know the meaning of words used. Simply ask the opposing attorney to please rephrase the question. If you do not hear the question, you can ask the attorney to repeat it.
Can you please repeat the question?
Be respectful. Treat everyone present with respect. You should answer questions politely. Speak loudly and clearly. When answering a question, you should speak at a volume that allows everyone to clearly hear your answer. When answering a simple yes or no question, you must say yes or no. The court reporter cannot record a shake or nod of the head. Don't interrupt. You and the opposing attorney should never be talking at the same time. The court reporter can only record one voice at a time. If you interrupt a question before it has been completed, you may answer incorrectly. Let the opposing side ask the question completely before starting your answer. If the attorney interrupts you with another question, you should pause, keeping in mind what you were going to say, and wait until the attorney is done asking the question. Then you could say something like, "Pardon me, I wasn't through answering the last question." After you have completed your answer, politely ask him to repeat his next question. Don't look at your attorney for guidance. When you are giving your deposition, you are on your own. There is no need to look at your attorney for guidance. If you do, the opposing side might think your attorney is coaching you. This will hurt your credibility. You may be asked questions that you just don't want to answer. Unless your attorney specifically instructs you not to, you will be expected to answer all questions. If your attorney has a problem with a question that's been asked, he will object to the question.
I object in a phase to physician-patient.
If your attorney objects, stop talking immediately. Let your attorney make the objection. Then wait for your attorney to tell you whether or not to go ahead and answer the question. You must not argue with the opposing attorney about how unimportant a line of questioning is. Also, when answering a question, it is a good idea to make eye contact with the attorney who asked the question. Don't let down your guard. Your attorney and the opposing attorney may engage in casual conversation. This may make you feel relaxed, but the court reporter will continue typing everything that is being said. You should avoid joking and wisecracks. This is a serious matter. Don't chat with the opposing side during breaks or after the deposition is concluded. You may unknowingly say something that may hurt your case. Don't volunteer information. Keep your answers short and to the point. Don't volunteer information that the opposition has not specifically asked you about. Listen to the question. You are there to answer questions truthfully and accurately, nothing more. The attorney may be friendly, but is not there to help you. If a question can be answered by a yes or no, that's all you should say. If the other attorney wants more information, wait until you are asked. Stay calm. You are not there to convince the other attorney how right you are or how wrong the opposing side is. Don't become defensive or upset about any questions that may be asked. You should never argue with the opposing attorney. Stay calm and politely answer all questions. Don't characterize your testimony. When answering a question, stay away from words that characterize your testimony, like honestly or seriously.
Honestly, I don't remember. Seriously, I didn't see him fall.
By using these words before an answer, the judge or jury might think that every other answer is untrue. Avoid using the words never and always. If the opposing side is able to find one exception, your credibility is lost. Do not complain or exaggerate your physical condition. You will be asked to describe any pain or other symptoms that you have had as a result of your injuries. You will be asked what pains or problems you still have currently. You should answer these questions honestly and in a matter-of-fact way. Do not exaggerate or complain about your injuries or problems. Don't try to be your doctor. You know where you hurt and how it feels, but you might not medically know your condition. Do not try to medically quote what your doctor has told you about your injuries. If you misquote your doctor, or you forget something, or misuse a word, you run the risk of contradicting your doctor. You can assume the opposing attorney has seen your medical documents and knows what your injuries are. It is best to speak of injuries in general, like, my arm was broken, or there is something wrong with my neck. It's important that you tell the other attorney about all of the other injuries that you've had. Don't leave anything out. At the end of your answer, you may want to say, "That's all I can remember at this time." Now, let's review the rules to follow. Arrive about 15 minutes early for your deposition, and don't discuss your case with anyone other than your attorney. Always tell the truth. You should not guess at the answer. If you don't remember, it's okay to say, "I don't remember." You should be respectful and polite to everyone at the deposition. Speak clearly enough for everyone to hear your answers. Do not mumble or nod your head. Don't interrupt. You and the attorney should never be talking at the same time. It is not good to look to your attorney for help when answering a question. You should use good eye contact with whichever attorney has asked the question. Do not let down your guard. A deposition is a serious matter. You should not make casual conversation with the other attorney and should refrain from joking and wisecracks. Don't volunteer information. Listen to the whole question, then answer only what they have asked. Do not elaborate. Do not get upset with questions. You should stay calm and answer the questions truthfully without becoming defensive and angry. Avoid using words like honestly, seriously, never, and always. Do not exaggerate or complain about every ache. Don't try to medically quote what your doctor has said about your injuries. Misquoting your doctor can create problems. Now let's go over some specific kinds of questions that you may be asked during your deposition. Question number 1 assumes facts that are not true. The other attorney may ask you a question that assumes a fact about you or the case that may not be true. This type of question can't be answered correctly because to answer it at face value is to agree with something that isn't true. An example might be, how fast would you drive when you took painkillers? It may be that you never drove while on painkillers, so the entire premise of the question is flawed. You must first correct the part of the question that's in error, and then answer the question. Question number 2 is an inaccurate summary of your testimony. At the end of a series of questions, the other attorney may summarize your testimony and ask you if this is true. But be careful. Instead of summarizing your testimony just like you gave it, he may try to get you to agree with something you did not say. Take a look.
So you heard your cell phone ring, looked over, and answered it. You talked for a while and then fell?
Yes, that is correct.
The natural human instinct is to agree with what the attorney says. Listen carefully and correct the false statements.
So you heard your cell phone ring, looked over, and answered it. You talked for a while and then fell?
That is all true, except that I did not say I spoke on the phone for a while before I fell.
Question number 3 involves choosing between 2 false statements. The opposing attorney may ask you a question where you have to pick between a couple of choices. For example, he may ask you, which is it, 1 or 2? This question can be tricky to answer truthfully because both of the options given may be incorrect. Here is an example.
After you fell, did you continue to talk on the cell phone or did you call for an ambulance?
You may be positive that it's not the first choice, but you doubt that the second choice is true. Just because there are only 2 choices given in the question doesn't mean that those are the only 2 possible answers. If the truth rests in a third alternative, then disregard the 2 choices that have been given to you and clearly state the correct answer. Let's review what we have talked about so far. Handle questions that assume facts that aren't true by first pointing out the falseness, then correctly answering the question. The other attorney may summarize your testimony, trying to get you to agree to facts that you did not say. You should correct the false statements before answering, or you may simply say, "Yes, that sounds about right." Be careful if the other attorney asks you a question where you have to pick between 2 or more choices. Here are some more questions you should be prepared to answer. Question number 4 asks, who is at fault? Listen carefully if you are asked questions pertaining to who is at fault concerning your case. If you say it was your fault totally or partly, you may destroy your case. You should be aware of the claims that are being made against the defendant and why they are responsible for your injuries. It is a good idea to discuss these issues with your attorney prior to your deposition. Question number 5 asks, have you told me everything? The other attorney may ask you, have you told me everything? The attorney is trying to close the book on your testimony so that if you testify about additional information later, then you look like a liar. If your case goes to trial and you remember additional information that you failed to state during your deposition, your credibility will be lost. The judge and jury will have doubts about your truthfulness. The plaintiff can avoid closing the box on her testimony by saying that she might not have mentioned everything because that's all she can remember at this time. Question number 6 deals with the management of your case. The opposing attorney may ask if you mind showing your income tax returns, being examined by another doctor of their choice, or whether you have an objection to them speaking with your doctors. These are questions that have to do with the management of your case and should only be answered by your attorney. Some attorneys may be blunt and ask you, how much do you want for your case? You should not give them a dollar amount. You may want to say,
We want a judge or jury to decide how much this case is worth.
let's review the second part of questions you should be prepared to answer. You should never admit fault to anything unless you have previously discussed doing so with your attorney. If the opposing attorney asks, "Have you told me everything?" you can state, "That's all I can remember at this time," or words to that effect. If the opposing attorney asks if you mind showing your income tax returns, being examined by another doctor of their choice, or whether you have an objection to them speaking with your doctors, let your attorney answer. Here are a few additional questions that you should be prepared to answer. Question number 7 involves words that have multiple meanings. The opposing side may ask what you can't do anymore due to your injuries. There may be tasks that you cannot do as well as you could before you were injured, or they may be more painful to perform than they were before your injury. You may want to clarify between the things that you are not able to do and the tasks that you avoid because it hurts or can't do as well as before the injury. Question number 8 involves factors such as time, speed, or distance. Please be very careful when answering any questions about time, speed, or distance. These questions need to be carefully thought out before answered. Give a specific answer only if you are 100% sure. If you are not completely positive, you may give an estimate. Make sure your estimate is reasonable, and you should explain it is only an estimate. If you really have no idea what the time, speed, or distance was, explain that you don't know. You should never guess.
What time did this incident occur?
I think the fall occurred about 5 o'clock in the evening. It's an estimate.
Question number 9 asks about your background. The defense attorney may ask you background questions, which range from where you were born to what was your salary at the time of the injury. If you do not remember, you can say that you do not remember or make the best estimate, telling them that it is only an estimate.
When did you and your family move to Texas?
I'm not sure. I think it was about 1989 or 1990. I'm estimating.
Again, don't volunteer additional information. Let's review the additional questions that you should be prepared to answer. Be careful when answering questions that contain words that have multiple meanings. For example, what things can't you do now that you could before your injury? Make sure you explain what things you absolutely can't do and the things that you avoid doing. Don't guess about time, speed, or distances. Give specific answers to such questions when you are 100% positive. If you give an estimate, make sure that it's reasonable. The opposing side will ask you questions involving your background. If you don't remember, say so. If you give an estimate, state that it's an estimate. Your deposition is a very important part of your case. By listening carefully, using common sense, and telling the truth, you will help your case. How you come across will be a major factor in settlement or whether a judge or jury finds in your favor. This is a lot of information to remember, but watching this video again will help better prepare you and ease your anxieties about your deposition. If you have any questions about your case or the deposition process, please write them down and ask your attorney prior to your deposition.